Hello, and welcome to the Washington Courts Report podcast, the official podcast of the Administrative Office of the Courts. I'm your host, Patric Haerle, and today we'll be providing an overview of the 2025 legislative session and bills that impacted judicial operations. For this, I am joined by Judge Rebecca Glasgow, Chair of the Board for Judicial Administration Legislative Committee and a Division II Court of Appeals Judge, and Dr. Haerle Perkins, Supervisor of the Office of Judicial and Legislative Relations for the Administrative Office of the Courts. So, Judge Glasgow, Dr. Perkins, Haerle, thank you for joining me so much.
Thank you, Patric.
Of course. So, during the 2025 legislative session, which ended on April 27th, we had 433 bills passing the legislature, with a number of them impacting operations of courts, AOC programs, and services. So, a lot of these bills are submitted by the Board for Judicial Administration. Judge Glasgow, could we go a little bit over the process of how the Board for Judicial Administration generates ideas for bill proposals and submits them to the legislator?
Sure. So I'll start with an overview of the Board of Judicial Administration, or BJA's Legislative Committee, and then Haerle's going to jump in with some more information about the process.
Sounds great.
So the BJA Legislative Committee recommends a slate of proposed legislation to the BJA for approval every fall for the following legislative session. So for this year, we'll recommend a slate in around September or October, and then that will be the slate for the 2026 legislative session. During session, the Legislative Committee also determines BJA's position and or what action BJA is going to take on other legislation that's raised by AOC staff, court-level associations like the SCJA or DMCJA, or other judicial branch entities like the Supreme Court Commissions, the Minority and Justice Commission, the Gender and Justice Commission, the Interpreter Commission, and other commissions. And so the voting membership of the committee includes the chair, which is me, and I'm also the Court of Appeals representative, and the BJA co-chair. So the BJA chair, one of the BJA co-chairs is always the Supreme Court Chief Justice, and the other co-chair rotates between the SCJA and the DMCJA. So starting soon, we will have a DMCJA co-chair. And then those two also serve on the Legislative Committee, along with an SCJA representative and a DMCJA representative. And when the chair is not from the Court of Appeals, there's a Court of Appeals representative, but we don't have double voting, so the chair does not vote twice. And then we have a bunch of non-voting members. I won't list them all, but they're representatives, additional representatives from the SCJA and DMCJA and other court and judicial branch entities like the Clerks Association, the Administrators Association, and the Supreme Court Commissions. And we have a charter that requires us to prioritize review of bills that are proposed by other entities or people when the topic is highly visual, controversial, or of great interest to the judiciary, when the bill applies to multiple court levels or the entire branch, or when there is or could be disagreement among court levels, associations, entities, or judicial branch partners. And I feel like that last piece is really important. It's important to us to have the BJA Legislative Committee be a clearinghouse where we all show up and honestly tell each other what our positions are on bills. And it may be that the BJA doesn't take a position on a bill where various entities or court levels disagree about how the bill should either be written or how it should proceed through the legislature or whether it should be adopted. But it's a place where we can all sort of gather and get information from each other about how each of the associations is going to act on legislation in the legislature. And then finally, we are working on an equity and access tool to make sure that even in the speed of legislative session, when we're all working really fast to determine positions on bills, we're pausing for a moment and thinking about how bills will affect different communities. So now I'll turn it over to Haerle for an overview of the policy proposal process.
Thank you, Judge Glasgow. So just a quick overview of the proposal process, which Judge Glasgow discussed or mentioned briefly, but so policy proposal submissions, they come through the BJA Legislative Committee and are ultimately what turn into AOC agency request legislation. And I'm going to just give an overview of kind of how we solicit those proposals, we review, prioritize, and then ultimately how they become agency request legislation. So following the end of the legislative session, a solicitation for policy proposals is sent to the judicial branch leadership. So this includes presiding judges, leadership for the various associations, and it's sent on behalf of the BJA Legislative Committee co-chair. And this year, the solicitation went out at the beginning of May. So we try to give people about 2 months to get their policy proposals in. And anyone in the judicial branch community who has a proposal request is welcome to submit the completed request form by the stated deadline. This year, the deadline is July 18th. So that is coming up in a little less than a month now. Once the deadline passes, I follow up with the requesters if needed, and then I present those proposals received to the BJA Legislative Committee voting members, who Judge Glasgow outlined above. And the presentation will include recommendations based on various factors, depending on the session that we're in. And some of those factors can include if the bill applies to multiple court levels, the current budget situation that we're in, timing, and then also the length of the session. So if it's a long session or if it's a short session. And then in September, those recommendations, so once the voting members, when I present those to the voting members of the BJA Legislative Committee, they vote on that. Their recommendations then move forward to the overall BJA for voting in September, like Judge Glasgow mentioned. So in September, we present to the overall BJA and they vote. And what they vote on, those recommendations ultimately become our agency request legislation. So the BJA is kind of our opportunity to speak with a collective voice since we are in a non-unified court system. And this is a really important step in that process. Once those are approved as the legislative slate, we hit the ground running, we being myself and the associate director. And so from October through December, we are working on strategy. We are trying to coordinate prime sponsors for the bills. And if there's any stakeholdering that's needed prior to session, especially if it's extensive stakeholdering with, say, like community advocates, we work with the requester to make sure that that is done ahead of session. And then in December, if we are ready and able, we pre-file those bills ahead of session actually starting. So about a month prior to session, there is the ability to pre-file bills, and that kind of just gets things in the hopper and ready to go for when session starts.
Yeah, and one thing that stood out to me immediately was there is really no downtime for the Board for Judicial Administration Legislative Group. You really are, the second that legislative session ends, gathering these proposals and going through the process, stakeholdering, like you said, making sure everything's ready to go. And going through, I think it's so important that, yeah, in the non-unified court system, we have something like the BJA, making sure everyone has a voice, everyone is heard and is able to submit their policy proposals. So now going a little bit into some of those policy proposals that passed this year anyway, can you highlight some of the important bills that passed this session related to judicial operations for the court community? And we will start with Haerle for this one.
Absolutely. So before I get into a review of any specific bills from the session, I do want to note that these are brief and incomplete bill summaries. If anyone is interested in the legislation that we're discussing today, I would really encourage them to read the legislation itself, the session law, and attend any applicable trainings that are being offered and review any existing educational resources on the topic to get those full details. Judge Glasgow and I are really simply just providing a high-level overview, and we are not the subject matter experts on the various topics that these bills cover. But with that said, I will discuss one of the important proposals that we received this past session for the 2025 legislative session that did not end up actually turning into a bill. We were able to work it behind the scenes and come to an agreement. But this is related to the Secretary of State's address confidentiality program and the inclusion of judicial officers in that. So the BJA Legislative Committee received a proposal request last session from the BJA Court Security Committee, which is now a formalized committee with the BJA. And they requested statutory revisions for the Secretary of State's address confidentiality program. The address confidentiality program, just briefly to overview, is the only current means for ensuring state and local government agencies shield personal data. And this applies to the county assessor property records and also the state voter records, which are some of the easiest ways to obtain personal information that can be used for harassment or targeted violence planning. So these are both addressed by enrollment through the address confidentiality program. But in short, the statute is written in a way that does not explicitly outline judicial officers as qualifying members for the program. And so without legislation, we worked with the Secretary of State's address confidentiality program staff last interim to clarify the qualification of judicial officers. They changed the wording on a form that previously required judicial officers to attest that they had already been the target of a threat or harassment, and clarified the application process for judicial officers as well. The bottom line is that the ACP, the Address Confidentiality Program, will accept judges regardless of whether there's been a current threat against them. And if judges are interested in the program, they can call the Address Confidentiality Program directly at 360-753-2972. And the ACP staff will provide the application with instructions for how judges can apply. So that is a very important piece. And I think as of late, there have obviously been some things in the media with the legislator in Minnesota who was recently murdered. And this is, of course, at the forefront of everyone's mind, especially elected officials right now. And so this is an avenue and a venue for judges to be able to protect some facet of their personal information that's out there.
Yeah, safety for judges, so important, right? Gotta make sure our judicial officers and leaders of court community are safe, and doing it in a way that doesn't require an extra bill seems, makes it that much easier, right?
Absolutely. And the staff at the ACP program were acknowledged that the statute is not where they want it to be, and something that they are also planning to work on, but that is something that they will take on when they are ready to do so.
It's great to hear.
Yeah, the next bill that I want to brief is actually a piece of agency request legislation. So engrossed second substitute House Bill 1174. This is concerning court interpreter statute revisions. This was prime sponsored by Representative Strom Peterson, and it's actually the second time we brought this bill forward. So in 2024, we brought this forward and it was unfortunately not successful. But I do think that it was really valuable because it educated legislators and primed them for it to be successful this session, which was great. So like I said, this was agency request legislation. The proposal was brought forward by the Interpreter and Language Access Commission. And the bill requests changes to Washington statute to provide better access to the courts and court services for individuals, regardless of their ability to communicate in English, and to update statutory verbiage in order to align with the operations conducted by AOC's court interpreter program and industry best practices. So we are very thankful that that got through. We worked very hard on that behind the scenes to make sure that it moved through the process. But I think that this is a really great step in improving access for individuals who don't speak English.
Yeah, everyone deserves access to justice, English speaking or not, right? So that's great to hear. And will we now be handing it to Judge Glasgow?
Yes.
Yes. So the next bill we're going to talk about is SHB 1620. This is a big one, and it involves parenting plans, and the prime sponsor was Representative Taylor. So this was SCJA request legislation, and it really is the result of heroic efforts by the SCJA Family and Juvenile Law Committee, who worked on this bill for many years. They had a multi-year process that involved a lot of give and take and compromise with stakeholders. And this was really tough this session because they really had to fight for the version of the bill that the vast majority of stakeholders supported, but there was a vocal but very small group in opposition. And so the BJA supported this bill along with many of the BJA's judicial branch partners. So there's a lot to this bill, and SCJA has been providing training for judges, and the Gender and Justice Commission hopes to follow up with training for attorneys. So this is just highlights. It's important to read the bill and take the trainings. It involves significant changes to 191, and by that I mean RCW 2609-191, which is the statute that addresses parenting plan limitations that a court can order in things like residential time based on certain prior conduct of a parent, for example. It changes guidelines for judges on ordering decision-making authority between parents or guardians and expands the court's discretion to some degree in that area. It adds provisions addressing when limitations are warranted for both parents. It amends provisions on dispute resolution in child custody cases and adds new provisions for limitations in parenting plans involving a parent or someone they reside with who has committed a sex offense against a child. And so there's a lot to that bill, and I really encourage you to attend a training or view one of the recorded trainings that will be available on Inside Courts. So the next bill I'm going to turn to is also a big one. This is SHB 1829 about tribal warrants, and it allows tribal courts to file an arrest warrant at the superior court in which the tribe is physically located, and then the superior court has to timely review the warrant. Where a warrant is justly filed in the superior court and the superior court makes a finding that probable cause exists to conclude that the tribal fugitive subject to the tribal warrant has been charged with a crime by the filing tribe, then the court must order the issuance of a state warrant of arrest, which then it expires at 6 months after the issuance of the warrant. The bill also gives standing in any state court to certified and non-certified tribes that are demanding extradition of a tribal member who is a fugitive under the Tribal Warrants Act. And tribal warrants may be entered now in NCIC or the Washington Information Center databases. So the Tribal State Court Consortium has provided training, I think, at the SCJA conference, and other trainings are in the works for both judges and attorneys. So because of the technical and time requirements, we really encourage you to sign up or view one of the recorded trainings.
Yeah, and absolutely you want to watch those trainings. We will be linking the bills in the episode description of this podcast episode for anyone who's interested in checking them out more. We have these big overhauls of parenting plans, of tribal warrants, so you definitely want to check those out, and I highly encourage anyone to. So those were some of the big bills impacting judicial operations, but not all bills in the legislature are necessarily that large or overarching. So Judge Glasgow, could you give us a brief overview on some of the other bills, some quick hitters that were passed this session?
Yeah, so I think Haerle and I are going to mostly alternate on these. So the first one is HB 1007. That concerns notice and small claim actions. This was actually DMCJA request legislation that the BJA supported. And this bill requires a notice of claim for small claims to state that the failure to appear may, rather than will, result in a default judgment against the defendant. And so this, yeah, again, that was a bill that was sponsored by DMCJA. So Haerle?
Yeah, the next bill on that list that we would like to discuss is Second Substitute House Bill 1207. This is concerning Superior Court clerk fees. This was actually agency request legislation by the Secretary of State, so outside of the judiciary, prime sponsored by Representative Tai. The bill creates an additional $50 surcharge for certain filing fees collected by clerks of the Superior Court. $25 of that is to go to the Judicial Stabilization Trust account and $25 to go to various accounts outside of the judiciary. So the BJA actually voted to oppose this, and we testified in opposition after informal conversations with the Secretary of State were unsuccessful. The collected fee is intended to generate funds for repairs to the Washington State Archives and to potentially fill gaps in the funding for the Washington State Library. And while the courts recognize that those are very important state programs and are empathetic to the need for funding, it is problematic that we would be funding that with court fees. The judicial branch has made a concerted effort in the last decade to move away from using court fees and fines to fund programs because they create unnecessary barriers when individuals are simply trying to access court services. So that is the reason that we opposed that. While we do understand the need to fund the Washington State Archives and the Washington State Library, both very important, we can't, with a clear mind, support funding that with court fees and fines.
Yep, of course.
Go ahead.
No, just want to make justice as accessible as possible to everyone. Limit those fees wherever we can, right?
Absolutely.
I believe before I cut you off, you're about to hand it over to Judge Glasgow.
Yes.
Perfect. So the next one we'll cover is EHB 1219, which concerns the Interbranch Advisory Committee. And this is another one that was prime sponsored by Representative Taylor. This bill extends the sunset date for the Interbranch Advisory Committee to 2031. The Interbranch Advisory Committee is just what it sounds like. It has representation and regular meetings among the BJA and key members of other branches, so the executive and the legislative branch, to discuss whatever topics are relevant to the branches at the time. And the BJA voted to support this, so we signed in pro to support this legislation. And next is Haerle.
The next bill that we want to just quickly go over is a second substitute House Bill 1391. This is concerning juvenile diversion programs. It was prime sponsored by Representative Cortez. This is a really important bill. So the bill ensures that youth who engage in diversion will not have their complete diversion included in their criminal history. In addition, a juvenile's parent or guardian may not interfere with the youth's choice to participate in diversion. Specifically, they cannot decline diversion on behalf of a juvenile and cannot prevent a juvenile from entering into a diversion agreement. It also allows the period of diversion to extend beyond the participant's 18th birthday and mandates that the court and communities provide effective services to referred and diverted youth to prevent formal court involvement. The juvenile courts are to provide data to the Administrative Office of the Courts, who will use the data in an annual report on the number of Washington youth who enter into formal diversion agreements. And this is not something that we have systematically tracked to date. So this is very important to get that data established so that we can continue to support those diversions moving forward. AOC actually testified in support of this bill. The BJA did not, but AOC testified in support specifically with regard to the research staff that is going to add to Whisker to look at the juvenile diversions in Washington. The next bill on that list that we want to briefly just touch on is Senate Bill 5021. This is concerning retention of court exhibits. This was actually clerk request legislation, so the Washington State Association of County Clerks brought this forward. It was prime sponsored by Senator Wagner. It's fairly simple. The bill is requesting a change in the statute regarding the retention of court exhibits. So they're amending the current 6-year retention period to 5 years. And the BJA voted to support this and signed in. And I'm going to hand it back to Judge Glasgow for our last bill on that list.
Yes, so the last one is 5745, which is about legal representation under the Involuntary Treatment Act. And this one was sponsored by Senator Dingra. This bill addresses requirements and procedures for appointment of defense counsel under the ITA, the Involuntary Treatment Act. It allows the Office of Public Defense to provide appointed counsel under the ITA when requested by the Healthcare Authority, which is then has a request from a county for an individual detained at a state facility. The bill defines state facilities, and it specifies that the Attorney General is responsible for representing state facilities in ITA proceedings. So that's our last one.
Okay, a nice collection of bills there, and while some not necessarily as big as our last round, all still very important. Interbranch Advisory Committee, huge source of collaboration for our stake and expanded improved diversion collection. I know I recently wrote an article on just how important and lacking the data around youth diversion is, and that's really something that we need to know more about. So that was looking backwards at this past legislative session, which was, even on a limited budget, a busy one, it sounds like. So I want to look forward a little bit more to the 2026 legislative session. What bills and topics should the courts and AOC expect for the 2026 session to be high on the priority list? And we'll be starting with Haerle, I believe.
Yeah, so that's a great question. We are entering into the second year of the biennium. So any bill that stalled or, as we say, died last session, it didn't make it past its cutoff date, it comes back to life in January. So there will be a host, every bill that we looked at this session and discussed, those will all be back on the table active in January if they did not previously pass. And so that is important to keep in mind. So there will be a ton of bills that we already know are going to be back that we need to be keeping an eye on and continuing to engage in conversations around. Some of those, 3 specifically, are actually agency request legislation that did not pass this session for a number of reasons. 2 of those, budgetary reasons. Another of those, I think, kind of just got caught up at the end of session when there were some larger bills being discussed on the floor and it didn't make it through. First that I want to touch on is Substitute House Bill 1144. So this bill is asking to add an additional Superior Court judge to Skagit County Superior Court. As I mentioned, it's agency request legislation, and it was prime sponsored by Representative Lukanoff. So that'll be the same moving forward this next session. She will still be prime sponsoring that for us. But it asks to take them from 4 to 5 judges in statute. And this bill stalled in the House Committee on Appropriations, so it'll come back to life there again in January and move from that point. The next bill on that list is House Bill 1510. This was focused on including appellate commissioners in the PERS Judicial Benefit Multiplier Program. It was prime sponsored by Representative Natasha Haerle. It's agency request legislation, as I mentioned, and it's asking to add appellate commissioners to the PERS Judicial Benefit Multiplier Program. The judicial benefit multiplier is the percentage used along with the service credit years and the average final compensation to set the retirement benefit for judicial officers. So we're just asking that the appellate commissioners be included in that. And this will be alive again in January in the House Committee on Appropriations as well. And I'm going to hand it over to Judge Glasgow for the next.
Yes, so the next BJA request legislation is Substitute Senate Bill 5133. The prime sponsor was Senator Claire Wilson. And what it does is it attempts to add caregiver status as a mitigating factor in sentencing. So this was a proposal brought forward by the Gender and Justice Commission. It was a recommendation that arose from the 2021 Gender and Justice Study on gender bias in Washington courts. And it's requesting a revision to the sentencing statute RCW 9.94A 535 to recognize caregiver status as one of the listed mitigating factors for the court to consider. It doesn't require, but for the court to consider in sentencing, because the family structure can provide support and rehabilitation for offenders, and failing to recognize caregiving status as a mitigating factor adversely impacts those who generally carry the burden of caregiving, which is predominantly women and families without resources. So this one is the one that stalled on the floor, so it'll be alive again in January on the Senate floor. So now I'm going to turn it over to Haerle for topics that we anticipate, more general topics that we anticipate arising in the 2026 legislative session.
Thanks, Judge Glasgow. So I think top of mind for many people as of late is the caseload standard and the criminal attorney shortage. The Washington State Supreme Court recently issued an order, an interim order, I believe was the technical term for that, regarding the caseload standards and a phased approach for implementation of those. There will be a formal order that's issued later, but they're continuing to have conversations around that. But we definitely anticipate conversations about that this next session because everyone has been waiting for those very patiently. I think the next topic and something that we saw come up this year and we see very regularly is judicial discretion. So I think were a couple bills this session that we discussed and looked at judicial discretion in some form. And so those will be alive again in January, and we will be continuing our conversations and continuing to engage with those prime sponsors regarding the specific language that is included in those bills. Another one of those kind of high up on the list is pretrial release. There was a big bill this session that was related to pretrial release, and we anticipate that conversation will come back full force in January. And then something that we talk about regularly, this is a term and a topic that we here in the judicial branch, I think, are maybe a little tired of talking about, but court unification. So the legislature is now interested in this conversation as well. Representative Taylor brought forward a bill this past session that unfortunately did not pass, but it looked at forming a committee to study court unification in a way that we haven't really looked at it yet to date in the state of Washington to see what can be unified, if anything, within our court system as it exists. So that will be back, and we are ready to engage in that conversation as we had done this past session as well.
Can I interrupt you for a second, Haerle, and say that one of the things that the BJA Legislative Committee thought might be exciting about that bill was the opportunity to talk to the legislature about unifying technology systems. So I know that unification is it can be controversial, but the BJA Legislative Committee thought about thinking about that proposed legislation as an opportunity to potentially seek statewide solid funding, like ongoing funding for some things. And so that's the way that we're approaching that topic.
Yeah, I think there were a couple different aspects that the committee that we were hoping would come to fruition with this bill would look at, technology being a huge component of that, but also looking at forms and other things of that nature that like standardization across the state could help with. So hopefully we are ready to engage in that conversation when it begins again. A couple other topics that we are anticipating that will be coming back: competency restoration, that is a big one, civil protection orders, and then, as always, court security. This is always a conversation that we have and something that we're constantly trying to improve because it is lacking in many areas of the state. And so court security is a big one. And then I do just have one final reminder in this conversation that it's going to be a really tough budget year again. So the budget woes that we experienced this session are not going away anytime soon. And so I think I just want to be very realistic in terms of expectations for decision packages that are being submitted, in terms of what the legislature can give us for policy as well. So just keep that in mind, is that we are not out of the woods yet. This is still going to be difficult for us. And so just keep your expectations realistic in that regard.
Yeah, those are some big topics, judicial discretion, caseload standards, pretrial release, court unification. Those are some big ones, and for a tough budget year, we'll just have to see how it plays out. I appreciate you both giving us a view inside your crystal ball, though, so we have an idea for the next legislative session. Well, that was all the questions I have for you. Thank you so much for joining us on the podcast today and giving us sort of this insight into the legislative process, into some of the bills that passed, and into next session. Like we said, please check out these full legislation on the bills that we'll link in the description on the webpage and on YouTube if you'd like more information. Haerle or Judge Glasgow, is there anyone else you'd like to shout out or anything you'd like to leave us off on? And we will start with Judge Glasgow.
So I just want to say how central the work that Haerle and Brittany Gregory, who has now sadly departed AOC, how important their work is during legislative session. Like, none of this would happen without them. And so we all owe them a huge debt of gratitude, the entire branch does, for making sure that our voices get heard by the legislature. And so thank you so much, Haerle, and hopefully Brittany will be able to watch this and hear our gratitude from afar. Thank you.
Well, thank you, Judge Glasgow. I will be sure to share your thanks with Brittany. And I just wanted to thank you, Patric, for the opportunity to be here and discuss these bills and what we can potentially expect in the coming session. So thank you for the time.
Of course, it's a huge amount of work for a small staff, so we really appreciate that. It's a great shout out from Judge Glasgow. And thank you again for coming on the show, and that wraps up today's episode. Have a great day, everyone.